Good afternoon, and welcome to today's Regulatory Transparency Project webinar titled West Virginia v. EPA 2 Years Later, Updates on the Major Questions Doctrine. We're glad that you're here. My name is Marie Blanchard, and I am the Assistant Director of the Federalist Society's Regulatory Transparency Project. We're pleased to have with us today a stellar panel of experts, and note, as always, the opinions expressed are those of the experts. Please find more about our experts at fedsoc.org. That is fedsoc.org. And in order to get right to the discussion, I will hand it off to our moderator today, who is Susan Dudley. Susan, over to you.
Thanks, Marie, and thanks to the Federalist Society for hosting this today. Let me start with very brief bios of our experts. Actually, I'll start with myself and then I'll go to the experts. So I'm the founder of the George Washington University Regulatory Studies Center and a professor in GW's Trachtenberg School of Public Policy and Public Administration. I served as administrator of the Office of Information and Regulatory Affairs from 2007 to 2009. We also will hear from Paul Ray, who leads the Heritage Foundation's work on regulatory and economic policy as director of the Thomas A. Rowe Institute for Economic Policy Studies. And he also served as administrator of OIRA, but from 2020 to 2021. We will hear from Elliot Gaiser, who is Solicitor General of Ohio, an office that he has held since last year. I noticed in looking at their bios, which you can find longer bios on the Federalist Society's page, that both Elliot and Paul clerked for Justice Alito, and they're both alumni of Hillsdale College. So excited to have both of their expertise here, and they're great experts to address today's topic, which, as Marie said, is West Virginia v. EPA 2 years later. So in the next hour, we'll examine the Major Questions Doctrine, its role in regulatory litigation, and what recent developments might mean for its place in administrative law going forward. I'm going to start with some questions, just some Q&A amongst ourselves, but then we welcome questions from all of you. You can use the Q&A feature in Zoom, and we can see your questions and we'll address them. So I had told them I was going to ask them to describe the Major Questions Doctrine, but maybe I think I will do it in a simplistic way that maybe only a non-lawyer can, and then they can amplify that. But according to the Major Questions Doctrine, it's Congress, not agencies, who should ordinarily resolve questions of vast economic and political significance. I think it's fair to say that it was a response to agencies purporting to find broad regulatory authority in ambiguous and sometimes decades-old statutory language. In Justice Scalia's words, courts should presume that Congress does not hide elephants in mouse holes. So Elliot and Paul, please feel free to improve upon that non-lawyer summary. But also, since this webinar is looking at West Virginia v. EPA, do you agree with some observers that the Major Questions Doctrine originated with that opinion? And I'll open that to either of you.
Well, thank you very much, Susan, and thank you all for being here. I will say no, it definitely did not originate with West Virginia versus EPA. That would be anachronistic, especially since the doctrine had teeth in that very same term. In October term 2021, the Supreme Court invoked that same language about vast political and economic significance in two other cases before the West Virginia versus EPA opinion was issued. That was the CDC eviction moratorium case, Alabama Realtors, and the OSHA vaccine mandate and test mandate case, which was on the emergency docket of the Supreme Court, but both relied on this idea that Congress reserves for itself the most important and significant questions. And it was really the West Virginia versus EPA case that was the first time that the court labeled the doctrine, as many in the scholarship had. Now, as far as scholarship goes, a justice on the Supreme Court, when he was then a professor, Stephen Breyer, was really the one who deserves credit for coining the term. In a law review article in the 1980s, he talked about how the Chevron deference doctrine worked. And he said that one of the exceptions to Chevron is when the agency is trying to tackle a major question that is more than likely to have been reserved by Congress. But I think you can go back even further if you want the true origins of the major question doctrine. I think you can go all the way back to the founding of the country. The framers of the Constitution divided and organized its powers across three different branches. And it was most concerned about Congress being an overweening and overbearing branch and a direct threat to the liberty of individuals and to the pre-existing powers of the separate sovereign states. And so they enumerated limited powers to Congress in a substantive fashion and reserved powers in the 10th Amendment in a substantive fashion, and then also preserved additional rights in the Bill of Rights against Congress's encroachment. But beyond that, it also established procedural protections. It involved the president's veto pen, for example, bicameralism and presentment, the fact that certain bills, those involving taxation, have to start in the lower house, the house that is more directly accountable through 2-year elections to the people. All of these divisions of power, federalism, the separation of powers, the Bill of Rights, were designed to create sort of a channel so that what Congress did was in service of the common good, but would not be over threatening to individual liberty. And it did so with a series of substantive and procedural protections. Well, as Congress has delegated more and more of its authority to the president and to the executive branch, agencies have started to regulate significantly more. And the major questions doctrine sort of comes from two different places in the West Virginia versus EPA opinion. And it's said it's sort of agnostic, the opinion for the majority of the court, as to where it originates. One is constitutional avoidance, that constitutional framework would be jeopardized if the president could start making major policy decisions, because all of those frameworks of protection, substantive and procedural for individual rights, would go out the window if the president could unilaterally utilize a pen and a phone to accomplish what the Constitution delimited to Congress through bicameralism and presentment. But it also says maybe there's an inference about how Congress tends to operate, sort of empirical judgment that as a general matter, Congress wants to get credit for, as it's made up of elected officials, the major policy choices. And it was pretty much as a matter of just assumption, unlikely to leave those questions to be delegated by one of the coordinate branches, by the president and his inferior officers. So the major questions doctrine is almost as old, I think, as the implicit principles in America's federal scheme.
I have very little to add to Elliot's excellent and thorough discussion or response to Susan's point. I'll just say that, of course, reading the text of statutes in context is as old as the federal court system, and so as old as the country. And really, the major questions doctrine is simply a particular instantiation or a particular way of reading text in context. The significance of the policy question under discussion, of course, should be part of the context within which the text of a given statutory provision is read. And it has, as Elliot points out, it has been part of the discussion of the context for many years now, going back several decades. And so, yeah, it's really it's a mistake to think of the major questions doctrine as a kind of doctrinal island. It's really just a particular embodiment of a longstanding and really undisputed principle.
Thank you both. Let's move on to how the question at hand is, how have things gone since West Virginia v. EPA? How have the courts applied and the major questions doctrine since, over the last 2 years? And in particular, we had that recent Sixth Circuit stay on the FCC's net neutrality rule. Paul, do you want to start with that one?
Yeah, and I'm glad to do that. So, so in West Virginia itself, I count some 8 factors that the court invoked to indicate that the question presented to the court was a major one, that the major questions analysis had to be undertaken. And the court was not clear in West Virginia which, if any, of these factors was necessary and which, if any, was sufficient for the determination that major questions analysis was appropriate. We still don't know the answer to that to that question of overriding importance. The court has applied the major questions doctrine in the years since West Virginia. It applied it most notably in Biden versus Nebraska. There, I counted 4 of the 8 factors present in the court's analysis, but the court again didn't take a position on which of these factors was necessary, which is sufficient. So on the question that is to my mind of greatest interest with regard to the NQD, we still don't know exactly when it applies. Various courts of appeals have applied the case as well. Susan mentioned the net neutrality stay decision, but there too we haven't really gotten a lot of granularity on which of the factors are of greatest significance.
Well, I think that you could read it the way that my friend Paul reads it, as saying, well, there's these sort of 8 factors and it's not sure which one is necessary and which one is sufficient. I think that there is actually one question that triggers the major question doctrine. And those various factors, Justice Gorsuch in his concurrence, joined by Justice Alito in the West Virginia versus EPA opinion, describes them as hallmarks or indicators that the major question doctrine is in play. The real question at the threshold is what the agency is asserting power to do and what limits on that power are there once that agency is correct about that particular decision. And I think the easiest place to see this is in the West Virginia versus EPA opinion itself. There was a comparison between the statute and the scope of the power that the agency was asserting. And if the agency can do the thing that it's trying to do in that particular case, then what limiting principle attaches to that statute? And I think in the Missouri, the case involving student loans, the Biden versus Missouri case, Biden versus Nebraska case, I think you can see the exact same analysis in the Chief Justice's opinion. It's if the agency can do this, what can't the agency do? And to me, that's important because a lot of people get wrong about the major questions doctrine that the agency action itself has to be one of vast political and economic significance. And many of the cases in that line are like that, where the case involves a $100 billion industry, or with respect to the OSHA vaccine mandate, it was going to subject roughly 84 million Americans to OSHA's power in a way that they had never been subjected to that power before. And so you can clearly see that those are major questions because they affect lots and lots of people. But that's ultimately not what I would say is the dispositive question. The dispositive question is, if the agency can do this, what can't the agency do? And if the agency can do basically anything on its interpretive theory that it's asserting as the basis for its regulatory action, then of course the agency can swallow Congress's powers whole and would have, by definition, powers of vast economic and political significance. And that political and economic significance triggering language, and it comes out of the Brown and Williamson tobacco case. And there, the agency itself wasn't doing something that was going to have, catastrophic consequences for millions and millions of people, but it was asserting for the first time that an industry that had never before been regulated by the FDA, tobacco, could be regulated in the first instance, even though that particular rule didn't affect very many people. I think that's also true in the MCI case. That case involved an interpretation of the term modify in the context of the Telecommunications Act. And that wasn't going to affect all too many people. But if the agency could use the term modify to do what it was doing in that particular case, then there was no limiting principle on what the agency could do. I think you can go all the way back even to the benzene cases, the AFL versus CIO case, also involving the Department of Labor and OSHA regulating the product, benzene products in the workplace, where the majority, the controlling plurality in that case, essentially said, if the agency is right about its authority, then it's likely that Congress inappropriately and unconstitutionally delegated its legislative power to that particular agency. And even later Chief Justice Rehnquist, who wasn't chief at the time, in his concurrence in the judgment, he would have found that Congress did in fact delegate unconstitutionally to OSHA when it gave them the power to do what the agency said it could do in that particular instance. Now, Susan, you mentioned the most recent case out of my home circuit here in the great state of Ohio, the Sixth Circuit, which is the federal circuit that governs our state, a per curiam in a stay order saying essentially that the FCC's net neutrality rule, reimposing the net neutrality rule, triggered the major questions doctrine and that once that major questions doctrine was triggered, the agency had an obligation to point to clear statutory authority, and that wasn't a burden that they were likely to be able to meet, and therefore, on the likelihood of success on the merits factor, the Sixth Circuit said a stay was appropriate. Again, that case did involve the internet, and that's something that almost everybody in the world now uses. So vast political and economic significance was pretty easy to see from the actual consequences of the rule. But of the factors that was most important, it seemed in that opinion, was one of those that Paul referenced, which is, the agency's kind of gone back and forth on this, and it hasn't really been clear that this is the longstanding position of the agency, which maybe makes it less likely that the agency is right about its authority in the current case. And so I think that the court is alive and well. The major questions doctrine is alive and well in the lower courts, continuing to be used and litigated. The state of Ohio is party to a number of litigations that challenge agency action. And we have argued in a number of those instances, sometimes quite successfully, that what the agency was attempting to do was make a major policy decision. And we've always maintained that that major questions doctrine analysis is triggered by the scope of the agency's asserted authority, not merely based on how many people are affected or how much money is affected by the given rule at issue. That, I think, is an important limit because it ensures agencies can't accrue authority through adverse possession. They can't simply say, well, we have authority to do all of this, but we're only sort of using this slim amount, this, 2% of the 100% of the authority that Congress has given us. And this isn't a major question because it only affects two people. There was an entertaining dialogue between Justice Alito, Justice Breyer, and the advocates in the West Virginia versus EPA argument itself, where Justice Alito asked about, well, what if the agency says we have 100% of the authority here, and that would be a major question if we used all of it, but it's not a major question because we're only using 2% of it right now. And to put a finer point on this, you can look in the transcript for this entertaining word. Justice Breyer said, well, wait a minute. What if it was the FDA saying we have authority to regulate tobacco? Major question. But we're only writing a rule having to do with 4-foot hookahs, and there are only 4 of those hookahs in the entire country. Would that still be a major question? And the advocates were forced to concede, well, yes, if you're regulating tobacco for the first time, it doesn't matter that you're only regulating 4 people, because now there's no limiting principle on the FDA's authority. So that's where I really rest the major question. And that's the message that I try to convey to courts and to my fellow litigants who are invoking the major questions doctrine. The major questions doctrine is about a comparison of the scope of the agency's authority asserted, not the sweep of the rule in the necessary real world, but what couldn't the agency do if they could do what they're asking to do here?
That's really a signature Justice Breyer question right there. I thought it might be helpful for our viewers to hear what the 8 or so factors are from West Virginia versus EPA. I think Elliot's read on which of the factors is most fundamental is a perfectly fair one. But the 8 factors that the court used are, I'll mention first the transformational nature of the assertion of agency authority. The court also pointed to the fact that the provision at issue in West Virginia was vague, it was ancillary, it was rarely used. The agency was using it in a way different than its historical use. The agency was using it in a domain in which the agency lacked expertise. It was using it in a way that had been considered and rejected by Congress, and it was the regulation at issue involved a particularly grave question due to political or economic sensitivity. Now, in Biden v. Nebraska, the court seems to me to invoke just 4 of the factors: transformational nature of the invocation, as Elliot mentioned, and then the difference from historical use, Congress's consideration and failure to act on the policy question at issue, and then the magnitude of the impact. So, yeah, thought folks may find that helpful.
Yeah, thank you. That is for someone like me, who isn't as good at reading the cases. So all right, so we've talked about how courts have responded or have been using major questions and responded to West Virginia, and what a major question is. How have agencies responded?
Yeah, so it's it's difficult to say what the long-term changes in agency regulatory processes are going to be as a result of the major questions doctrine, not least because there are a lot of other important changes to administrative law happening at the same time. I think what we can say is this. West Virginia and Biden v. Nebraska send a strong signal to agencies that regulations are safer from judicial review the closer they are to the agency's long understood powers, and you might say the more small c conservative they are, the less they represent a transformational uh, um, change to the agency's authorities. So I think you certainly see pressure from the courts on the agencies to justify the regulations in terms of their longstanding authorities, and also probably pressure on the agencies to minimize the impact of the regulations as well. I do think you see hints of these of the influence of these factors in regulations post-dating the West Virginia case. I think of the SEC's um, climate disclosure rulemaking, in which originally, some of you know, the SEC had proposed to require Scope 3 disclosures. The agency did not ultimately include that requirement. Perhaps it's hard to know exactly why, but perhaps in response to the perception that that was a more aggressive interpretation of the agency's longstanding authorities, and so would subject to heightened scrutiny under the major questions doctrine. I'll say also that I think while that pressure on agencies is important and can shape regulations in important ways, the scope and contours of the doctrine are they're fuzzy enough that it's hard for an agency to say that it's certain that a particular approach would fail under the major questions doctrine. And so for political appointees at agencies and in the White House evaluating the regulations to push, you know, the receipt of counsel from an agency that a regulation would certainly be unlawful is a very different thing from counsel that a regulation might fail under the major questions doctrine. And so I think it's I doubt that that the political judgments of the president and the highest officials will be significantly affected by the major questions doctrine, just given the doctrine's fuzziness.
I agree with Paul that I think the most important question for agencies is how much of a misfit is it between the agency's historic and widely understood public mission and the rule that the agency is undertaking right now. So I'll talk about a piece of litigation. An appeal is ongoing, but Ohio, together with Kentucky and South Dakota and a number of other states, it was a 21-state coalition, filed a suit regarding the Federal Highway Administration's attempt to impose a greenhouse gas target on state departments of transportation that, of course, manage the surface of the roads and have a significant amount of grant money from the Federal Department of Transportation. And the agency there said this is not a major questions case because all we're doing is establishing targets, and we think that the amount of cost that it'll impose on states is going to be in the hundreds of thousands, because all you're going to have to do is establish targets. And those are declining targets, and we're not really going to do very much to withhold grant money one way or another. That's their argument. The states prevailed in district court, now on appeal, everywhere that this has been litigated, making the argument, no, this is in fact a transformation of an agency that has historically done infrastructure, roads and bridges and physical infrastructure, into regulating for the very first time the vehicles that transit those roads. Instead of regulating the concrete and the physical infrastructure, you're now going to regulate what travels on that infrastructure. And the judge in our case, I'm most familiar with, said, well, yes, this is a major question. I think the anti-example is at the same time that the US Supreme Court considered the OSHA vaccine mandate, it also considered the CMS vaccine mandate, which imposed on roughly 10 million healthcare workers an obligation to receive one of the COVID-19 vaccines that was in use at the time. And the Supreme Court, in a per curiam, upheld that mandate. And there were 4 justices who were in dissent. Justice Alito wrote a dissent. Justice Thomas wrote a dissent. Justices Gorsuch and Barrett joined each of those dissents. But what seemed to me to be an interesting way to think about that case is, well, HHS, CMS, and healthcare workers and vaccine, that doesn't feel like quite the mismatch as OSHA and vaccines. OSHA does workplace safety. OSHA doesn't do medicine. CMS sort of does medicine. Maybe that fit between the vaccine mandate there doesn't transform that agency into doing something so far outside of what its historic mission is. Now, the Federal Highway Administration doing, instead of physical infrastructure, doing, regulations on what travels on that infrastructure, well, that made the Federal Highway Administration do something else. And so I think that that's maybe the easiest thing for agencies to ask themselves is, will this pull us outside of what is widely and publicly understood and likely to be understood as by courts as our genuine and an ordinary role? Now, of course, that's not going to be a dispositive factor because, of course, the FCC does regulate internet service providers. And yet, attempting to impose common carriage-like regulations on internet service providers was considered by the Sixth Circuit quite recently to stray outside of its statutory authority. So that's not dispositive, but I do think it's maybe a useful piece of guidance for agencies.
Well, and also for the internet, the FCC net neutrality, the fact that the pendulum had swung, that the FCC had gone back and forth several times on whether they had that authority and that was the right approach. Paul, did you want to add anything there?
No, Elliot's response is very good and capacious.
All right. So now let's turn to this year's Supreme Court opinions, which really were very exciting or interesting, interesting year, let's say, if you're an administrative law aficionado. So how would you say, and this is a big question, so feel free to take pieces of it, how would you say the recent decisions affect the major questions doctrine? Whether do they reinforce it? I've heard people say they reinforce, also that they may moot it, especially Loper Bright, obviously, and Ohio.
Yeah, so I'll start with the Loper Bright question. Kastenstein has an article from a few years ago arguing that there are 2 major questions doctrines, one that creates a carve out to Chevron, and one that has to do not with deference, but just with the limits of agency authority. So it's pretty clear that that the first version of the major questions doctrine no longer exists because Chevron deference no longer exists. Perhaps there's some version of this version of the major questions doctrine applicable under Skidmore deference, or it's hard to say at this point. But pretty clearly that version of the major questions doctrine has ceased to exist. But of course, as a doctrinal matter, overruling Chevron does not affect West Virginia or the line of cases it relies on with regard to the substantive limit on agency authority. So then we have to ask ourselves whether, as a practical matter, the major questions doctrine no longer has teeth in light of Loper Bright. And it does seem to be the case that a number of cases that involve agency regulations implicating major questions may also, as a practical matter, need deference to agency interpretations to survive. So it's not hard to imagine that under Loper Bright, the major questions doctrine will be invoked successfully less often, simply because now there's another basis not to sustain a regulation that might fall within the purview of the major questions doctrine. But that's not always the case, right? So Chevron deference had to do with ambiguous provisions authorizing agency action. It didn't have to do with vague provisions. There are plenty of provisions in the U.S. Code authorizing agencies to act that are simply very capacious. They're not ambiguous. They're just broad. agencies continue to enjoy wide discretion to act under those provisions. It may well be that an agency action that at least arguably fits within the broad bounds of a provision of that sort, nevertheless would resolve a major question, and so would trigger major questions analysis. So bottom line, I'd say with regard to this version of the major questions doctrine, while its applicability may be, as a practical matter, somewhat lessened by Loper-Bright, nevertheless, it still has important work to do.
Well, I agree with Paul that the exception to Chevron no longer applies now that Chevron no longer is a thing. I think one thing that's interesting about Loper-Bright is that the Chief Justice's opinion said, well, stare decisis, and in fact, statutory stare decisis, which is a much stronger form of stare decisis, applies to every one of the old cases that used Chevron to uphold an agency's action under the various statutes. So it's sort of an attempt to say, well, this is not retroactive, it's sort of prospective. One way to think about the major questions doctrine is a prospective non-delegation doctrine. That this isn't going to say anything about what Congress has done in the past and what agencies have done in the past. If they've done it for a long time, we're sort of, it's over and done. Major questions can't overturn those things the way that maybe a strong form non-delegation doctrine might start to question the existence of certain regulations and certain statutes that authorize agencies to act. It's sort of a this far, no further. If you've never done it before and Congress hasn't reauthorized it or clearly authorized it, you can't go any further than that going forward. And I think in a practical matter, then the major questions doctrine and Loper-Bright are fellow travelers. So agencies can do things that they've done before. They can rely on stare decisis in the past with respect to some cases, although we'll see how some of that is litigated. I think there's going to be some fresh look at some of the regulations that maybe have been upheld, or maybe they're different from similar regulations that have been upheld under the old Chevron regime. I think the biggest debate in the major questions doctrine is between sort of the Justice Gorsuch joined by Alito concurrence in West Virginia versus EPA versus the Justice Barrett concurrence for herself in Biden versus Nebraska. And the question there is the major questions doctrine simply a label that we've affixed to read statutes in context? It's textualist, and you're just reading the statute in context. And if you do that, that's all you need to do. It's not really anything different from strong form textualism. If that's the version of the major questions doctrine that we have to deal with, then Loper-Bright is basically saying same thing, right? Loper-Bright says courts are there under the EPA, authorized by Congress to interpret the law, to say what the law is, and that's what the court should be doing. And that's no different from what the major questions doctrine under the Justice Barrett concurrence, I think, is supposed to do. The Justice Gorsuch, Justice Alito concurrence, and a lot of the language in the Chief's majorities in West Virginia versus EPA, as well as in the Biden versus Nebraska case, seem to make it seem like something else. It's a substantive canon. And as a substantive canon, it says, wait a minute, once you're in the world where the agency has triggered the major questions doctrine, we're going to look at things that are sort of not strictly within the bounds of the text. And that context can include the agency's history, but it can also include something that isn't exactly the same thing as the legislative history that Justice Scalia criticized, committee reports and floor statements, things of that nature. But congressional action and inaction can be, in fact, a dog that does bark when it comes to the major questions doctrine. And so that makes me think it's much more likely to be in the substantive canon. So the fact that Congress didn't authorize the Department of Education when it had the opportunity to authorize it to forgive student loans in the way that the administration had been doing so. The fact that Congress didn't authorize the CDC eviction moratorium when it had the opportunity to. The fact that Congress had the opportunity to do all kinds of things in the greenhouse gas and climate change rule and had, in fact, all those bills had stalled out. And the fact that that's cognizable at all, congressional inaction on a topic, as one of the ways that you can sort of see that this is a question of vast political and economic significance, and also to sort of show the implausibility of the agency being tasked to do something that Congress thought about giving them the power to do and declining to give them the power to do, makes me think it's much more of a substantive doctrine for the current Supreme Court majority. But I think if that's the substantive doctrine, then Loper-Bright doesn't have anything to say about that at all, because this is sort of out there and travels independent from Loper-Bright.
Okay, I think now let me invite people from who are listening or tuning in to start popping your questions into the Q&A because we'll be turning to that soon. But let me ask one more question. We've talked about the effect that it has on what agencies are doing, what courts are doing. What about Congress? What effect does it have on Congress's authority?
So there's a way in which the West Virginia line of cases limits Congress's powers, but a much more important way in which it expands Congress's powers. Um, it limits Congress's powers to, well, to delegate the resolution of major questions to agencies, right? It makes it more costly to do so through requiring a kind of clear statement from Congress. And so we would expect that such a clear statement is harder to negotiate within Congress, and so the costs of including a clear statement are higher, and so Congress is less able under the major questions doctrine to delegate the resolution of major questions to agencies. Not unable to do so when an adequate majority of members wish to do so, but it's harder to do. But I think more importantly, the major questions doctrine preserves Congress's ability to avoid accidentally delegating resolution of major questions to agencies. Congress quite frequently delegates powers to agencies that that for whatever reason Congress does not feel the need to cabin very thoroughly. We might think of the HEROES Act, in which Congress gave ability to the Department of Education to make certain modifications to student loan repayment plans and details. Congress makes delegations of that sort all the time. It couldn't make delegations with the facility with which it makes them today if it had to worry every time it delegated that it was giving away its authority to resolve the most pressing political and economic questions of the day to agencies. Indeed, I think there's one of the strongest supports for the major questions doctrine seems to me to be precisely the profoundly undesirable state of the world state of a world in which Congress had to always be worrying with every delegation to any agency that it was sort of giving away the farm, as it were. So the major questions doctrine allows Congress to give minor questions to agencies without accidentally giving away major questions to agencies, and that seems to enable Congress's abilities in a pretty serious and significant way.
I would agree with that. I think that there are really two Congresses that you can discuss, and I draw on my former boss, former OIRA director, but also Judge Naomi Rao's work on this. It preserves the Congress that the Constitution creates, and it reestablishes and reasserts its power in a very fundamental, important way. And that's the power of Congress to act as a collective Congress. The collective Congress, one of its primary powers, is the power to say no, unless you have a majority, or even if you have a significant minority because of the protections that the rules like the filibuster and other kinds of rules involving committees and the lower house, things like that. It basically protects the ability of Congress to say, actually, we're not going to do this at the federal level. This is going to be something that's left to states or something that's going to be left in the hands of the other branches within their core constitutional limits. But it does, in fact, disarm sort of individual members of Congress on certain instances, individual members who maybe want to insert an ancillary provision and are able to do so and command a majority for that in a vague sort of way, and then benefit from that by sort of helping to direct what the agency rulemaking happens to be. And so there were instances in some of these challenge policies where members of Congress who did not command a majority were applauding the thing that they couldn't get done through the congressional process being done by the executive branch agency, whether that's student loan repayment or the CDC eviction moratorium or the national vaccine mandate or the sort of regulation of greenhouse gases, to do generation shifting and destroy the coal-fired power plant industry. All of those instances of congressional minorities or individual factions within Congress are disempowered by the major questions doctrine. And I think it's helpful to return, of course, to think about the schema of Congress within the whole constitutional order. It was supposed to have broad powers over enumerated categories of substantive legislative authority and not have power outside of those things. And then procedural protections to ensure that even when it exercised its core prerogatives, it was doing so with compromise and consensus representing the whole of the nation. And that if those things can't be done, then the presumption of our constitutional order is that no one may do them at the federal level, that they must instead be left to the people at large or to the individual laboratories of democracy in the states. And as you know, the Solicitor General of the state, of course, that is a welcome development to have the Supreme Court and lower courts reinforce that substantive limit that was part of the original compromise that created the Constitution as a compact between the people in the several states.
Susan, I'll just also add, you asked about the effect on Congress, and you asked earlier about the effect on agencies. We should also think about the effect on the president. And it may be that the most important limitation created by the major questions doctrine is with respect to presidential action. Presidents tend to be worried almost exclusively about major questions, right? That's what they run on. Particular sets of answers to major questions. And so agencies certainly have incentives to use their authorities to expand their domain. But it may be, indeed, I think it is the case, that presidents have incentives that are even stronger. The reason for that is that, well, there are a few reasons for it. Agencies considered by themselves, left to themselves, have particular areas of specialization. But presidents tend to, well, the buck stops with the presidency, and more the president is perceived to be a kind of omnicompetent officer. Anything that goes wrong on a president's watch is considered to be his fault in some way, and so presidents have very compelling incentives to try to use all powers that they have, and that is to say all powers that agencies have, to address all problems that are presented during their administrations. And so the incentives that presidents have to grasp any authorities that any agency subject to their control has to address a particular problem are quite strong. And so we might think that presidents, we might think that presidents, more than agencies, have a tendency to take the authorities of an agency and repurpose them to address a new pressing question, a major question, in fact. So I think the major questions doctrine applies precisely to the questions in which presidents have compelling incentives to try to repurpose agency authorities. And so I think probably the limitations of the doctrine are most significant for presidents.
Presidents who have a phone and a pen. All right. We are now turning to audience questions. So please, if you have a burning question for our experts, submit them through the Q&A. We have one from Stephen Dewey that I'll read. To what extent do you think the West Virginia v. EPA case and the two recent Chevron cases may affect legacy regulations that have been in place, particularly as a result of the 1984 Chevron decision? You addressed this a little bit earlier, Elliot. What are your thoughts on that, both of you?
I don't think it's impossible that they will affect legacy regulations. And I think that there will be incentives for litigants, those who are subject to those regulations or whose interests are impaired by those regulations, to try to utilize, for example, the corner post ruling from Justice Barrett in the Supreme Court that held that the 6-year statute of limitations was not just a statute of repose. Instead, it was a true statute of limitations that, as the Sixth Circuit has long held, accrues when a party is adversely affected and injured by the agency's action. And so there will be incentives to try and go after legacy regulations. I haven't seen very much evidence that the major questions doctrine has been used to attack in litigation regulations that have been on the books for a long time. And I think there's sort of a reason for that. Those regulations, they have sort of gotten the authority that Congress has given them has already sort of been blessed in that respect. And to the extent that there have been challenges to those regulations, those challenges are the law of the circuit in many of those places where the litigation might occur, or the law of the Supreme Court. So I do think that the most powerful effect of local right and West Virginia versus EPA is prospective. And you can sort of see why maybe the justices on the Supreme Court and judges would think that that is the more prudent approach, because you don't want to unsettle everything and sort of throw all the cards up into the air. You could say, well, this is the line, don't cross it moving forward.
Yes, that seems right to me. Of course, that leads to a kind of strange situation in which there might have been a major question style challenge available to a regulation when an agency first issues it, but because the agency effectively walked its regulation by such challenge, then a major questions challenges is not available later. So it's a sort of curious state of affairs, but I think Elliot's right about that.
So we don't have any questions in the queue, so I'll make a last call for that. But in the meantime, Paul and Elliot, do you have any comments you'd like that we haven't discussed, or questions for each other?
Well, I have a question for Elliot. How has the major questions doctrine shaped your litigation strategy at the state?
Well, that's a very good question. And I can, of course, only talk about Ohio's litigation strategy and not other states. But I have observed that litigants across the board have taken, some of them have taken a more aggressive and some have taken a less aggressive approach with respect to the major questions doctrine. To me, the most important thing, whenever Ohio is going to be involved in a regulation, first of all, the state has to be injured. And if a state is injured by that regulation in a meaningful way, then you're looking for what are the arguments that are available. And sometimes that argument is readily available. I mentioned the Federal Highway Administration's attempt to impose on Ohio an obligation to set declining CO2 emissions targets for its roads and bridges and physical infrastructure. And how we were to accomplish that was going to be, I think, quite expensive for the state. And it jeopardized our grant programs, which would also be very expensive for the state. And so we made the major questions doctrine argument there. We're also party to the litigation involving the SEC's climate disclosure rule. In fact, the Ohio Bureau of Workers' Compensation, which has its own unique fund invested in public markets and private markets, that's going to be adversely affected by the regulatory burden on publicly traded companies that is going to reduce and decline the performance of those shares. We're making the major questions doctrine argument there, and it's a very straightforward one. The Securities and Exchange Commission was never authorized by Congress, much less in the 1934 Exchange Act, to play JV EPA. And so it's far outside of its lane. But there are also cases that involve agency action that don't readily trigger the major questions doctrine. Susan referenced earlier the Ohio versus EPA case, where the Ohio Department of EPA had promulgated a state implementation plan that was disapproved for the ozone requirements of the Clean Air Act. And then we had imposed on us a federal implementation plan that didn't respond to the comments predicting that if you disapprove all these state implementation plans, and some of those disapprovals are challenged successfully in court, which they have been across the country in many of the circuits of the country, then your assumptions underlying your 23 state federal implementation plan for ozone regulations is no longer going to be rational, will be arbitrary and capricious. And it is arbitrary and capricious for them to have not even responded to those comments and instead to just slap a blanket severability clause and claim that their work is good enough. At the oral argument for that, Justice Kavanaugh said, well, the EPA says we're going to do this plan for 23 states and it's rational and cost-benefit justified. And commenters said it's not going to be 23 states because of the way that you disapproved the state implementation plans, it's going to be some smaller group than 23, and that's not going to have the same cost benefit analysis applicable to it. And then the EPA was, and in Justice Kavanaugh's words, goose egg, said nothing at all. Well, that's not really a major questions case. That's just a straight up arbitrary and capricious APA case. And the Supreme Court 5-4 held that Ohio is likely to prevail on the merits of its claim, together with the other states and the industry petitioners in that case, and therefore issued a stay of the federal implementation plan and its obligations that are going to cost Ohioans and the Ohio government, as well as the Ohio industry, significant costs and cripple our electric grid and throw it all into reliability problems. The major questions doctrine wasn't perhaps the best argument there. That wasn't really what was in play. And so, there are lots of administrative law cases that are not going to be administrative, major questions doctrine cases, but where the states are going to continue to make arguments under the APA, even though there's no major questions component to the case as such.
Great, thank you.
Yeah, so barring further questions, I think we can wrap up. So I will thank both Elliot and Paul very much, because I know I learned a lot, and turn things back over to Marie.
Yes, thank you, everyone. Thank you to these fantastic panelists for sharing their points of view, and thank you to the audience for tuning into this program. And for more content like this on the regulatory state and the American way of life, please visit us at regproject.org. That is regproject.org. Have a great day, everyone. Thank you again.